Hi, everyone. We're going to get started in just a second. I'm just going to give everyone a minute to connect. All right, so let's get started with today's CRS seminar. I'm Sharry Aiken. I'm the director of the Center for Refugee Studies. I'm also an associate professor at Osgoode Hall Law School. Today's seminar, as you know, is about maritime refugee arrivals and security and admissibility to Canada. When I was thinking about the topic for today's seminar, I was thinking about a couple of boats in addition to the boats that we'll be hearing about today. I was thinking about the Homeric, which is the boat that my grandfather came to Canada on as a displaced person from Germany in the 1950s. And I was thinking about his arrival on that ship as a displaced person and thinking about the contrast to the story that we're going to hear today about the Sun Sea and the Ocean Lady. I was also thinking about a couple of other ships, and these were the boats that arrived in Canada in the 1990s on the West Coast from the Fujian province of China. And just as I wouldn't be sitting here today without my grandfather coming on the Homeric, I don't think I would be here today were it not for those those ships that arrived on, excuse me, on the West Coast of Canada, because when those ships arrived, I was doing my undergraduate degree in political science at the University of British Columbia. And it was the extraordinarily negative response to the arrival of those ships, language about go home, language about Canada being invaded, language that was very much replicated with the arrival of the Sun Sea and the Ocean Lady. It was those issues that really got me interested in immigration and refugee issues and led me down a path to law school, led me down a path to pursue my doctorate in areas connected to refugee law, and ultimately led me to become the director of the Center for Refugee Studies. So responses to ships are interesting. I think they are productive things for us to think about, and so I'm delighted that we'll be talking about that today. I'm also delighted about our two speakers. We have Sharry Aiken, who is well known to the Center for Refugee Studies. She's an associate professor at Queen's University. She's the academic director of the graduate program in immigration and citizenship law. She's played leadership roles in advocacy and in research relating to immigration and refugee law. She's currently a visiting scholar with the Center for Refugee Studies. Unfortunately, it's been a virtual visit because of COVID, but we've been pleased to have Sharry around virtually. Our other speaker today is Harini Sivalingam. She's a doctoral candidate in the Socio-Legal Studies program here at York University. She has been pursuing research that focuses on the lived experience of maritime forced migrants as they encounter Canada's border control regime. She has been involved in the Law and Society Association, in CARFMs. She's also currently an adjunct instructor in the graduate diploma in immigration and citizenship law at Queen's. So both of our speakers have lots of expertise to share with us on this important topic. I'm going to hand things over to them. They'll provide their presentations and then we'll have some time for questions. So over to you.
Thank you, Sean, for that wonderful introduction, and thank you to you and Michelle for organizing today's seminar. So we look forward to an engaging discussion on maritime arrivals and securitized inadmissibility to Canada. We wanted to begin today with a land acknowledgement of the lands, territories, and waters on which we are living and working as uninvited guests in Toronto. That's where myself and Sharry are joining you from. We do realize that we are gathered virtually, so we do encourage you all to acknowledge the Indigenous territories that you are situated upon and joining us from here today. So we acknowledge that this land is the traditional territories of many Indigenous nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, and the Haudenosaunee, and the Wendat people. In addition, the research for this presentation was also conducted on the lands and territories and waters of many Indigenous nations, including the Saugis First Nations, the Coast Salish people, and the Mohawk Nations. We are grateful to have the opportunity to research and teach on these lands. We acknowledge that as settlers, our work would not be possible if not for the stewardship of these lands, territories, and waters by Indigenous peoples. We're also grateful to be able to drink a glass of water and not have to boil the water first. So it is particularly important for our work to acknowledge the colonial, racist, and violent practices that continue to impact Indigenous peoples and their relationships with the lands, territories, and waters. And to help situate our talk today, I'm reminded of the fact that when the MV Sunsea, the second of the 2 Tamil boats, arrived on the traditional territories of the Saugis First Nations, Indigenous elders from the Esquimalt First Nation reportedly held a spiritual prayer welcoming the safe arrival of these newcomers onto their traditional territories. And as you will see from our presentation, this is in stark contrast to the reception that these refugees eventually received from the Canadian state. So we also wanted to start this presentation with this political cartoon for you to reflect on, as we feel it's very illustrative of Canada's securitized approach to maritime refugees. And over our time together in the next hour and a half, as we engage in this discussion, we hope that we spark some engagement and insight on some of the elements that are expressed in this cartoon around Canada's approach to asylum seekers. And we'll, towards the end of the presentation, you'll kind of see those themes hopefully emerge. And we look forward to discussions and questions at that time. So I just wanted to bring you an overview, a roadmap for today's seminar. So after my introduction, Sharry and I will briefly share a few words on the conceptual and theoretical orientation to anchor our talk today. After that, Sharry will provide a brief overview of the framework around Canada's security-related inadmissibility and anti-smuggling provisions and procedures, after which I will introduce the case study of the Ocean Lady and Sunsea refugees, including their arrival and detention. And Sharry will provide an overview of the legal proceedings that wound up at the Supreme Court of Canada. And I will present some of my research findings on inadmissibility and the consequences of Canada's securitized approach towards the Tamil refugees. And our intention is with the seminar is to fill in gaps in existing scholarship, as Sharry will describe in the next couple of minutes, on securitized migration by recentering the voices and perspectives of refugees who are actually impacted by these laws and practices and policies. And finally, Sharry will wrap up with our seminar, drawing together the themes that we discuss in relation to what's taking place around the world currently. So I'll now hand over the reins to Sharry.
Thank you, Harini. So just a few words about the theoretical orientations to situate our conversation today. First, to talk a little bit about securitization. You see the reference in the title to security and admissibility, but we're really talking about the broader process of securitization in the context of migration policies. And in that regard, drawing on international relations scholarship that defines securitization as a process of social construction that pushes an area of ordinary politics and law into the realm of security through the use of both discursive and legal categories such as threat and danger, aimed at justifying the adoption of extraordinary or exceptional measures. Now, we want to acknowledge that there's an extensive literature on the Ocean Lady and Sun Sea, specifically addressing media representations, the discourse analysis regarding the maritime arrivals. There's also been some important work on the legislative reforms that ensued in the wake of these arrivals. And in that regard, we're drawing in particular on some foundational work by University of Ottawa criminologist David Moffat. But there's been relatively scant attention paid to the question of how the genealogies of race and racialization are so central to understanding Canada's response to these maritime arrivals, as well as the broader migratory processes and experiences. And so we're really trying to both recenter the experience of the refugees themselves, but also framing it in terms of the question of race and racialization. And we argue that the bordering practices that ensued in response to these arrivals are made possible by an operating logic that is highly racialized. And we seek to demonstrate this with evidence. In this instance, not just of the legal reforms, the public discourse, there's been a lot of work on that, but on the actual impacts of these practices on the refugees themselves. Indeed, as Harini mentioned, the refugees are at the center of the story we hope to tell, and that's one of the important contributions of the research itself. So a few words about maritime arrivals generally and this process of racialization. We can go back to the 20th century, 1914, and the arrival of the Komagata Maru and the Canadian state's response. I'm sure many of the folks in our audience will recall that there were some 376 passengers aboard that boat. One of them brought a legal challenge attempting to disrupt the operation of a continuous journey rule, which effectively prevented the immigration of British subjects from the Indian subcontinent to Canada. The test case litigation was unsuccessful. All of the passengers were returned to India. 20 of those passengers were subsequently detained and brutally tortured. We can flash forward to 1939 and the arrival of the MS St. Louis, when some 900 Jewish refugees from Nazi Germany were seeking asylum in Canada, again sent back. And this time, many of those passengers transported to concentration camps where they were tortured and murdered. And then we can flash forward to the Ocean Lady and Sun Sea. Now, obviously, I'm leaving a number of arrivals out, but the point here is to really emphasize the continuities in relation to the Canadian state's response. And they also stand in stark contrast to how Canada, along with many other Western states, responded to the Indo-Chinese boat crisis in the 1970s. But there was an important difference there. None of those boats actually made it to Canada. They were stuck in the region. And ultimately, Canada stepped up along with many other governments to organize one of the most massive resettlement efforts ever. But again, you can see that the very distinctive context of the Vietnamese boat people compared to the arrivals of the Komagata Maru, the Ocean Lady, and the Sun Sea. And we argue that to understand this, we need to center race and racialization. And we also want to emphasize that while the presentation today focuses on a singular case study, these are not exceptional. And hopefully we can begin to tap into some of that in the Q&A that follows our formal presentation. So back to you, Harini.
Thank you, Sharry. So as Sharry mentioned, there hasn't been that many instances of maritime refugee arrivals to Canada. But when maritime arrivals do happen, they're framed in public discourses of being crisis-driven, despite the relatively and comparatively infrequent numbers of refugees arriving by sea, at least to Canada and in the global context as well. So Canada does not have clearly as many boat arrivals of refugees as you would see in the Mediterranean in Europe or in Australia. So in that context, it is very infrequent to have boat arrivals come to Canada. But these boat arrivals of refugees have consistently been characterized by state and public discourses in apocalyptic terms, such as floods, tides, waves, by media and politicians. And as such, the spectacle created by maritime arrivals, especially of refugees who are racialized, as Sharry mentioned, have elicited securitized reactions from state authorities, the popular media, and the general public within those destination states. So securitization of migration, we argue, reproduces and reinforces those racist discourses of refugees themselves being cast as threats to the host and receiving countries instead of being in need of protection. So rather than the refugees being seen as being in need of protection, they're portrayed as dangerous others that the nation state itself needs protecting from. So maritime spaces, we like the literature and the scholarship that we've examined enables the construction of refugees as securitized legal subjects through what has been described as the border spectacle by scholars such as Nicholas de Genova, and also what we described as the spectacle of the boat. So as highlighted through the scholarship, the spectacle of illegality is sustained through increased enforcement measures such as detention, interrogations by security officers, and deportation ultimately. So maritime arrivals of refugees provides a microscopic examination of Canada's racialized and securitized laws and policies that hinder the vast majority of refugees that are securitized in this manner from actually accessing legal streams to seek refugee protection through the state. So next, we're doing a bit of tag team, Sharry here. So I'm now gonna tag Sharry in. She's going to take us through the actual framework, the legal framework around securitized inadmissibility.
So the first thing we want to mention is securitized inadmissibility casts a very wide net. So the inadmissibility provisions in Canadian immigration law are those provisions that catch prospective entrants at the front end on their arrival, and they can also serve to operate on the back end to be the reason why people are removed from Canada. But it is a very wide net, and let's take a look at the provisions in particular. So next slide. So here we've got the first provisions relating to security inadmissibility. And these are very broad. You're not just inadmissible on security grounds, if you pose a security threat yourself, but if you are or were a member of an organization that engaged in those suspect acts. And the legal scholars amongst us will know that the courts have given the concept of membership a broad and unrestricted interpretation. And the case law that has emerged in this area stands in stark contrast to the much more rigorous definitions that are offered in the criminal law. So very wide net, very broad. It's also interesting to note that some 96% of cases of security inadmissibility in Canada involved individuals from the global south between 2002 and 2013. And in that regard, we're drawing on the very important work of Angus Grant in his doctoral thesis. And Grant emphasized that Sri Lanka was one of just 4 countries of origin that accounted for the vast majority of all cases during that time. So that in and of itself is interesting. Now, keeping in mind that we're not just talking about the arrivals from the Ocean Lady and Sunsea, but a much broader population, but still it's an interesting statistic. So that's security inadmissibility. But there's also inadmissibility on grounds of organized criminality. And in relation to the Ocean Lady and the Sunsea, these 2 provisions reinforced each other. So in this regard, we're looking at Section 37 of the Immigration and Refugee Protection Act, which renders someone inadmissible on grounds of organized criminality for engaging in people smuggling. With one exception, this is the savings clause. You're not inadmissible if you yourself arrived with the help of a smuggler, okay? So if you personally relied on a smuggler to get to Canada, you're okay, as long as you didn't do anything else, as long as you didn't help anybody else who came with you, you're not inadmissible. This is the text in the law that was in place more or less at the time that the refugees arrived in the Ocean Lady and the Sunsea. Also, something important to understand about these provisions, and that's the legal threshold. So I talked about how you can be inadmissible on either security grounds or on grounds of organized criminality. But by the way, there doesn't have to be a very high threshold to establish either of these forms of inadmissibility. Indeed, they're established on the basis of reasonable grounds, which, as we're trying to show here, is just a shade above mere suspicion and well below the standard civil test of a balance of probabilities, and of course, well below the criminal threshold of beyond a reasonable doubt. So in other words, it doesn't take much to end up getting caught up in these inadmissibility provisions. Next slide. So what are the consequences when someone is deemed inadmissible for either security grounds or organized crime? Well, first of all, to understand, it's usually permanent. In other words, it's very difficult to get out from under it. You become automatically ineligible to pursue a refugee claim. And on the back end, you're barred from accessing protection through a pre-removal risk assessment from persecution. You also find yourselves subject to indefinite surveillance and reporting requirements that can continue for years. In other words, there's no finite period of, well, you're going to have to report to Immigration and Refugees Canada for X amount of time. It's indefinite. You're barred from family reunification. You can't initiate any application to reunite with family, nor can you travel outside of Canada without risking not being able to come back in. Worse, you're often subject to detention or the alternative, a form of house arrest, and ultimately removal, deportation. Those are the kitchen sink of consequences for inadmissibility. Now, what are the remedies if you find yourself subject to an inadmissibility designation? Well, I have on purpose this slide to highlight the fact that these remedies are little more than trying to find a needle in a haystack. First of all, there's no right to appeal inadmissibility on the part of the person concerned. The minister has a right of appeal if you happen to be successful at first instance, but you don't. You do have access to judicial review by the Federal Court of Canada, but it's a very limited remedy because the grounds for a successful judicial review are very narrowly drawn. You also have no access to the discretionary remedy of a humanitarian and compassionate application. That procedure is supposed to be available to remedy the deficits in Canada's immigration laws and to provide a mechanism for people who otherwise don't qualify for status to have one. But interestingly enough, if you're inadmissible on security grounds or for organized criminality, you don't have access to what we call H&C. And while you do have limited access to a pre-removal risk assessment, as I mentioned a moment ago, you don't actually obtain a permanent form of protection from persecution. More often than not, you'll be granted a temporary status, a right not to be removed from Canada, but not a form of solid, secure residence status. There is one further safety valve. Indeed, judges in numerous court cases refer to provisions for ministerial relief as a safety valve. But for those of you who've studied this so-called safety valve, you'll know it's anything but. There are provisions for a highly discretionary form of relief that has to be granted directly by the minister, and is based on the minister coming to the conclusion that your presence in Canada is not contrary to the national interest, with national interest being interpreted broadly. So in effect, almost any reason can be a reason not to provide relief. So drawing on publicly available statistics, we know that between the years of 2009 and 2019, immediately after the arrival of the Ocean Lady and Sunsea, only some 24% of ministerial relief applications were granted. We also know that the average processing time was about 10 years, and that the backlog of undecided cases would take 28 years to clear at that rate of processing. We can also share anecdotally that of the passengers on the Ocean Lady and Sunsea who sought ministerial relief, there hasn't been a single decision granted. So that's the so-called safety valve. We need to also understand the offense of human smuggling as it's defined in domestic immigration law. It's essentially a criminal offense to organize, induce, aid, or abet anyone from coming into Canada. And you'll see that, the text of the law is written in such a way that it doesn't sound like it's being targeted at refugees per se, but we'll see how it operates in practice and see what you think. One thing I want to emphasize here, to demonstrate the securitization process at play in the text of the law, is that the penalties for contravention of this offense or of this provision with respect to a group of 10 or more people include fines of up to $1 million or life imprisonment or both. So really draconian penalties. And of course, if convicted of this offense, an individual is automatically inadmissible with all the consequences in addition to these criminal sanctions. So I'm going to pass it back to Harini at this point to do a deeper dive into our case study.
So after that excellent overview of Canada's legal framework around securitized immigration processes and inadmissibility, I'm going to now introduce our case study of the Ocean Lady and the Sunsea that we feel demonstrates how the securitized framework of governance was operationalized and deployed against the Tamil refugee arrivals. So for over 3 decades of armed conflict in Sri Lanka has produced millions of Tamil refugees who have fled Sri Lanka, while many of those refugees remained in nearby countries such as India or in transit states that we'll describe a little bit later towards the end, such as Indonesia, Thailand, and Malaysia. Canada has become home to the largest Tamil diaspora in the world outside of South Asia. So in 2009, as the armed conflict in Sri Lanka came to a bloody and brutal end, with international atrocity crimes committed as the world turned basically a blind eye to the humanitarian suffering, those who survived the onslaught were desperate to escape and flee, fearing for their lives, and those who managed to leave the island sought out refugee protection. And brings us to the case study. So on August the 13th, 2010, two Navy tugboats escorted a cargo ship carrying Tamil refugees, 374 men, 63 women, and 55 children. So the MC Sensi was entering the unceded territories of the Sagis First Nation when Canadian officials intercepted the vessel. And this was the second boat of Tamil forced migrants or refugees to arrive on the western shores of Canada within a year, with the MV Ocean Lady carrying 76 Tamil men having previously reached that same port, or like the same area in October 2009. So the government response to these arrivals began before the Sensi was even docked and arrived on Canadian territorial waters. And they were securitized right from when the Ocean Lady itself arrived. So various government officials described the Tamil refugees as human smugglers and terrorists. For the Canadian government, the Tamils were seen primarily as security threats rather than as refugees in need of protection. And we can see that through the discourse around various Canadian government officials that constructed the arrivals as a crisis that has overwhelmed a broken refugee system, thus justifying the need for what they perceived were legislative reforms to fix these leaky borders. So the narrative that was deployed even before the boats entered Canadian territorial waters. And a clear example of the securitized approach versus a more humanitarian approach is that the Canadian government's chief spokesperson for all matters relating to the boat arrivals was the Minister of Public Safety. So he was the chief spokesperson. He was the one that spoke out widely on the boats, and not the the Minister of Immigration. And so so we see some quotes here and some of the points that the public safety minister at the time, Vic Toes, that basically tried to link and describe those on board as human smugglers, terrorists, in these highly securitized discourses. So the Canadian government's actual response to the boat arrivals was swift and severe. The Canadian government proceeded to deploy securitized tactics that hindered and delayed the Tamil refugees from seeking refugee protection in Canada. And so just to give you some context of what was happening in Sri Lanka at the time, or over the next 10 years or so as these boats arrived, is that at the time that the boat arrived, there was still 100,000 civilians that remained in army-run detention camps. And the rule of law basically collapsed. And there was significant impunity for abuses by state officials, which continued. And in 2015, and you'll see why that date is significant as in the next couple of slides when Sharry presents the Supreme Court cases, there's still reports of serious human rights abuses and widespread practices of torture against those who are detained by the government. And bringing it to fast forward to the current situation where human rights situation is at an alarming decline. There's growing militarizations, and Tamil and Muslim and civil society groups are increasingly being targeted. And this happens right at the present day, the present week. We've seen the oppressive tactics being deployed against protesters of the current regime. So that's to contextualize what was going on at the time, and just to highlight the fact that these abuses still continue in Sri Lanka. So bringing it back to the boat and its arrival, it's clear that detention was a technique that was actively and aggressively sought out by the government in a response to the Tamil boat arrivals. So an internal CBSA memo detailed that this was a purposefully an active and aggressive strategy sought out by the government in response to the Tamil boat arrivals. So this internal CBSA memo confirms the strategy, and it says that you can see the quote here. They wanted to use detention as to the maximum advantage, even if there was, even with the knowledge that this might be, limited in cases where there's no legal grounds to detain exist. But they still wanted to ensure that they pursued detention across the board for all the people that arrived. And inadmissibility was also used as a means to circumvent the refugee determination process for the Tamil refugees. So we'll see this a little bit more closely in the next couple of slides. But as Sharry also mentioned, the allegation of inadmissibility results in a suspension of the refugee claim proceeding until the inadmissibility issue is determined. So this strategy was of using inadmissibility as an alternative or in addition to the more cumbersome and resource-intensive process of ministerial intervention. And this was also highlighted as a very active strategy that they were going to aggressively pursue to help circumvent the Tamil refugees' abilities to obtain refugee protection. So the government did intervene in almost every single IRB hearing and actively opposed those who were ordered to be released from detention by the IRB. And just wanted to highlight here the, in the case of the Tamil refugees from the Ocean Lady and the Sun Sea, the government's immediate response to their arrivals was to intercept the boats and detain everyone, including children. So although they were technically called detained, the children were still held with their mothers in detention centers. So all the men and women without children were held in provincial jail, and women with children were held in a provincial youth detention center. And 6 unaccompanied minors were taken into the care of the BC Children's Aid Society. And the most egregious case of separation was the separation of a minor from his father, who was the only parent that he was traveling with. And you'll see the powerful words and the description in this quote on the screen of how that impacted the father and his son as well. So it was gut-wrenching when I conducted this interview. And just anecdotally, I wanted to let you know that when we were conducting this interview, the son was in the other room, and you could see, as he was describing that moment, he went right back to that place, right? And you can feel the emotions, and you can feel the fear that was in his eyes. He looked over to the door where his son, inside the room where his son was, as he was recalling the story. And it was quite jarring to hear that that detailed account of that separation on arrival. So sorry, I went too fast. So in addition, detention was much longer for these refugees than typical. So just to highlight that for the Ocean Lady, they were detained on average for over 3.5 months, and for the Sun Sea, it was for over 4.5 months. And so I mean, this is the average, right? So there was still one of the last to be released from detention took almost 4 or 5 years, I believe. And for those who underwent inadmissibility proceedings, though they were detained far longer than other refugees, as the CBSA relied on the provisions of URPA that allowed the detention to continue while the minister inquired about the reasonable suspicion that they were inadmissible. And this was, again, a deliberate strategy on the part of the CBSA to argue for detention for all the refugees. And they produced it, they used any applicable ground to detain, including identity, which statistics has shown was rarely used as the grounds of detention. But as you can see, it was used in 75.3% of the detention review hearings in the Sun Sea. So just really briefly before I hand the reins over to Sharry to describe the legal proceedings in the Supreme Court cases, another impact of the detention was that was highlighted by the Tamil refugee those who arrived, was that they were interviewed or interrogated very intensely and aggressively, and for some, they actually described it as being mental torture. So while in detention, they were repeatedly interrogated by the CBSA and RCMP officers. The interrogations were multiple and lengthy, some lasting up to 8 hours at a stretch of constantly repeating the same questions, even though clients or the claimants had previously answered them or denied the allegations that they were being accused of repeatedly in these interrogations. So having provided that overview, I'm going to hand over of the arrival and the tactics that the Canadian government used on their arrival. I'm going to hand the reins over to Sharry to describe in more detail some of these specific case studies.
Thank you. So we've talked about detention. The inadmissibility proceedings happen next, and we'll share with you the case of B306 as he was identified, a young Tamil man from northern Sri Lanka. He was hungry and in poor health when he boarded the Sunsea. Shortly after departure, the Thai crew abandoned the ship. 12 people, including B306, took over various duties during the 3-month voyage. He cooked meals and performed lookout duties in exchange for food. He had no role in planning or organizing the trip. So that's important. And we're just using this one case as kind of emblematic to help everyone understand what happened with these inadmissibility procedures. So his case was adjudicated. Whoops, there's another slide that goes before that. There we go. His case was adjudicated before the Immigration and Refugee Board, the Immigration Division, and indeed the decision maker found that B306 was culpable of people smuggling. The decision noted that his watchkeeping duties helped to prevent the potential interception of the ship as it proceeded to Canada. His work as a cook ensured that the crew had prepared food to eat. Consequently, he aided and abetted the coming into Canada of persons who didn't have proper visas. The board found it was irrelevant whether B306 himself was a refugee claimant and was not regarded as a member of the crew. There was no distinction, the board found, between actual people smugglers and the people who aid them. So that was the decision at first instance. Now, as I mentioned, there's no appeal. So the case went to judicial review and ultimately went its way up to the Supreme Court of Canada, where in 2015, the court heard constitutional challenges to these inadmissibility provisions and the human smuggling provision in a sort of combined set of cases. And collectively, these cases sought to challenge both the scope and substance of Canada's anti-smuggling provisions, provisions which had effectively criminalized refugee mutual aid and undercut asylum, right? And I mention that, in particular because anybody branded as inadmissible, deemed inadmissible, is automatically barred from accessing refugee protection, right? So these were the challenges, and B306 case was in amongst them. So we're not going to go into great detail in this presentation on what the Supreme Court decided, but the upshot was, from both cases, that refugee mutual aid was effectively decriminalized. In other words, even though on the face of the law, you were in effect exempted from inadmissibility if you arrived yourself through the help of a smuggler, the law had been interpreted up until this time as if you were helping anybody else aside from yourself who were traveling with you, whether they were a family member, a friend, or someone from the same town. If you were with them and helping them, you were automatically cast in the net of inadmissibility, the court decriminalized that and said refugee mutual aid on a common voyage should not be criminalized. And what they did in effect was read down these provisions in the law. They didn't strike them down. They didn't, say the law was all wrong, but they effectively provided a new interpretation. So let's take a brief and somewhat closer look. In the case of B010, the court emphasized that acts of humanitarian and mutual aid, including aid between family members, do not constitute people smuggling. Merely aiding in the illegal entry of other refugees in the course of collective flight to safety should not constitute inadmissibility. So that's an important statement. And in the companion case of Abuela Napa, we see the court emphasizing that the purpose of these anti-smuggling laws is effectively criminalize the smuggling of people in the context of organized crime. It doesn't extend to permitting prosecution for simply providing help to family members or providing humanitarian or mutual aid to undocumented entrants. And the court emphasized that a broad punitive goal that would catch people in such a wide net and prosecute them was actually inconsistent with legislative intent. So those were considered legal victories, right? They reined in the effect of these broad interpretations. The problem is that the benefit of these legal victories did not translate very directly to the passengers of the Ocean Lady and the Sun Sea. And that's where I'm going to really hand things back to Harini, and we're going to look at the actual impact of these decisions by the Supreme Court.
Okay, thank you, Sharry. So that was a great overview of how the two Supreme Court cases and legal proceedings clarified the clarified the law on mutual aid and material benefit. In this next part, we're going to explore the impact of these legal proceedings on the most impacted, the Tamil Maritime refugees. So in the aftermath of these Supreme Court cases, as you can see from this slide, there were limited benefits in reality of those who were actually caught up in the admissibility proceedings. So the Supreme Court cases benefit really the few cases only benefited the few cases that had not already been deemed inadmissible, or those who had hearings that were close to the schedule close to these cases, and who had counsels that were able to argue for a stay of proceedings. So as this lawyer who was interviewed said, those who were found inadmissible on the wrong definition of human smuggling, who were not able to reopen their appeals due to the way that the legal system and the framework of the legal system and the limitations were basically out of luck. It certainly didn't benefit those who had already been deported back to Sri Lanka. So what we're going to go into right now is to look a little bit more deeper into specifically how admissibility proceedings were deployed against the Ocean Lady and Sun Sea refugees. So we're going to take a closer look, and according to the statistics obtained by the IRB, there were 101 admissibility hearings for the Tamil Maritime refugees from both the boats. And as you can see from these numbers, the securitized grounds for inadmissibility were primarily utilized against these refugees. So the two provisions that Sharry described or looked at, so section 24 sub 1 security was the primary grounds alleged for inadmissibility for the Sun Sea, and for the Ocean Lady, section 36 sub 1 on criminality or human smuggling, section 37 sub 1 on organized criminality or human smuggling was the primary grounds for admissibility for the vast majority of the Ocean Lady claimants. So there is that notable difference between the Ocean Lady and the Sun Sea, where the security grounds were used much more for the securitized grounds were used much more for the Sun-C claimants. And so this change in tactic is a strong indication that invocation of inadmissibility was simply a smokescreen to hinder access to the refugee determination process than any real concerns about security and human smuggling. So while the government relied less on human smuggling provisions for the Sun-C cases, they were still subject to these securitized inadmissibility proceedings on the grounds of security. So you did see that shift. So some of the cases, what happened was that instead of using the Section 37 organized criminality provisions, the government used the security inadmissibility provisions instead. So you can see that highlighted in this chart. So the next thing we want to look at is now that we know the grounds for inadmissibility and how those were deployed between the two boats and the impact, we want to look at how did these inadmissibility hearings actually go. So the next slide shows the outcome or results of the admissibility hearing before the IRB as of April 2019. So of those 101 admissibility proceedings against the refugees, the outcomes were largely unfavorable to the Ocean Lady claimants, of which 64% were found inadmissible and issued removal orders. While the Sun-C claimants fared a little bit better at the admissibility proceedings, 23% were still issued removal orders. So the percentage of those who were allowed to remain, and so who were basically successful in overcoming inadmissibility allegations, remained roughly the same across the two boats. So at 28.6% for the Ocean Lady and 31% for the Sun-C. So this higher rate of withdrawal of admissibility proceedings for the Sun-C is a positive indication of the impact of the Supreme Court of Canada litigation. However, what this translates to into raw numbers is that there was a total of 29 removals, 25 of which deportation orders were issued against the Tamil refugees. So 9 from the Ocean Lady and 20 from the Sun-C. So you still see that there is still a significant impact, especially for those who were already deemed inadmissible, despite the legal victories at the Supreme Court of Canada. So, oops, I have one more slide. So we also wanted to contextualize this within the admissibility proceedings within the larger acceptance rates of the Tamil refugee arrivals at the IRB. So one of our key arguments is that the securitized inadmissibility was utilized as a strategy that hindered or prevented the Tamil refugees from access to seek refugee protection status in Canada. And to contextualize that impact of securitized inadmissibility, it is illuminating to look at these acceptance rates and the fact that the majority of the claimants who actually had access to a refugee hearing were eventually successful in their claims. So over the years, these numbers have fluctuated as some of the claims were appealed and redetermination hearings were held. So this data is from 2019, and some of the finalized numbers might have shifted as the last remaining refugee hearing and redetermination hearing took place. However, initially, many of the claimants were either rejected or positive determinations were appealed by the minister. And this process took many years, with many of the claimants being stuck in limbo, awaiting a refugee determination hearing. And in particular, as it relates to, and you will see this in the next slides as I share the experiences of the Tamil refugee arrival, the implications of the inadmissibility proceedings was that they really further delayed the access to an actual refugee hearing, because those who had allegations of inadmissibility had to overcome the inadmissibility process before being able to resume or initiate their refugee determination hearings. So many of those delays include having to wait years for their hearings. But most of the claimants were eventually successful in seeking refugee protection status. So while these numbers may seem promising, it's important to contextualize them also, to contextualize these refugee marine refugee arrivals of these two boats within the wider context of IRB claim acceptance rates from Sri Lanka in general. So during that same 10-year period of 2009 to 2019 that these claims were being adjudicated, claims from Sri Lanka varied from a high of 96% acceptance rate in 2009 to a low of 47% in 2013. So while these stats and numbers are insightful, and it's difficult to really draw any firm conclusion on these numbers alone, what is important is to hear from the Tamil refugees in their own words and the impact of that securitized legal processes such as inadmissibility have impacted on their lives. So in the next few slides, I'll be presenting qualitative research from my fieldwork. So in 2019, I conducted 27 semi-structured interviews with refugees who arrived on both the Ocean Lady and the Sun Sea, as well as refugee lawyers and NGO caseworkers. And these interviews were conducted in Vancouver, Toronto, and Montreal. And I analyzed the data and came up with some thematic themes that run across the vast majority of the Tamil refugees' experiences. So I'm going to really quickly, in the next couple of minutes that we have, run through some of the key themes that emerged that relate to the securitized processes that we've been describing. So the first and the probably the most significant impact that was felt across the board for those, especially those who were subject to admissibility proceedings, was delays. So even those who were able to overcome inadmissibility allegations or whose admissibility proceedings were delayed faced long delays in getting access to refugee determination hearings. So the claimants endured years of legal proceedings to overcome an admissibility finding. So for example, even though they were initially found inadmissible, this quote from this Sun Sea refugee that I interviewed, he was initially found inadmissible, but was eventually successful at a judicial review in federal court. And so after years of battles, he was finally successful in overcoming his admissibility. But those lost years we'll never be able to reclaim, right? And we'll address those in a couple of slides when I talk about one of the other significant impacts, which is separation from his family, which had a profoundly negative impact, not only on this refugee, but also his family that was left in Sri Lanka in limbo, waiting and being separated from him. So in this particular case, it took, and you'll see, I share another quote from this refugee and on the impact of family separation. So the other really significant impact of these delays and inadmissibility is just being in the state of legal limbo. So this claimant that that the quote is above had a negative admissibility finding, and he exhausted all legal remedies available on admissibility. And this was a persistent theme among many claimants who were left in legal limbo, and they were in this state of uncertainty of their precarious status. So he described being in this state of stress, of constant stress, not knowing, today and tomorrow, like everything, is the same. Like he doesn't know, right? He doesn't know when his status is just very precarious, and this left him in a very highly vulnerable state. And many refugees from the Sun Sea are in similar situations in this, very vulnerable, unpredictable state. As Sharry mentioned, one of the significant consequences of securitized inadmissibility is the limited legal remedies available. So this is a quote from a refugee who was from the Ocean Lady, who was actually helping other refugees from not just his boat, but from the subsequent boat, the MV Sunsea. And he was describing a fellow refugee who was, had this limited pre-removal risk assessment. And he just describes that, like, this refugee came to him and is like, I don't feel I'm Canadian. I don't feel I have the same rights. I have no time, sense of time, and just that, sense of not having access to any ways to come out of the state that he's in, of not being able to apply for permanent resident status and being insecure in his status. So highlights the limited nature of the legal proceedings for those who were securitized, and that sense of not being able to overcome or have a stable status. So another key theme or consequence that Sharry mentioned was surveillance. So those who undergo securitized legal proceedings continue to live under surveillance. There's strict reporting requirements, and they actually had a very negative impact on these refugees' everyday lives. So for this particular refugee, he had to report to CBSA for 3.5 years until he eventually overcame his inadmissibility process, the proceedings. And so that constant state of having to go and report. So I believe he said it was every 2 weeks at first, then twice a month. But he still had to report in person, still had this, sense of surveillance and reporting requirements that had a really negative impact on his everyday life. So another key theme right across the board for both refugees that were, that were subject to inadmissibility proceedings, whether they were successful or not, was delays in family reunification. So obviously those who were unsuccessful in admissibility hearings continue to be separated from their family. But as I mentioned, I was going to describe this, the case of the refugee who was describing the impact of his family separation on his life. This claimant was only reunited with his wife and other 2 children last year in 2020. Oh, sorry, this year in 2022. I think the COVID's messed up my sense of dates and timings. So it was actually only this year in January, after overcoming inadmissibility, that he was finally reunited with his family more than 11 years after he arrived on the Sunsea. And so just to put some context into this, his daughter was only 2.5 years old when he left her and was on this boat, and she was now 14 years old. So the most difficult part of the refugee journey for many of these refugees was the decades that they spent separated from the rest of their family. The other key consequence of securitized legal processes is this feeling of being stuck or immobility. So as Sharry mentioned, they're unable to leave the country. They're not able to be reunited with family members. So this sense of being stuck was highlighted by this refugee who shared the detrimental impact of these restrictions on his mobility. So he wasn't able to see his dying grandmother on her deathbed. And he described, and I have to read out this quote because it was just so powerful to me, is we are in this kind of in between somewhere and nowhere. We don't know how to go. We go forward or backward or get away from this place. I don't know, just stuck. And that was a really apt description of that process of immobility that these securitized refugees had to endure. And of course, we have the ultimate consequence of securitized practices of inadmissibility is deportation. So while I wasn't able to interview anyone who was actually deported during my field work, the looming threat of deportation still lingered among those who remained in Canada. The fear of deportation lingered with them for many years and lurked at every corner. So while it's not clear how many of the Tamil refugees were eventually deported, anecdotally, refugee lawyers have said that it's only been a handful that have been deported from the MV Sensi and the Ocean Lady. But we do know the fate of those of those who were deported that have been documented. So, for example, and I'm going to use the pseudonames that the IRB uses. B016 was found inadmissible, and he was deported to Sri Lanka in July of 2001. And upon arrival in Sri Lanka, he was arrested, detained, and tortured for almost a year. His family eventually secured his release through bribing officials, and he was subsequently detained again and interrogated by authorities in 2012. And after he was documented his arrest and torture in an affidavit that he submitted to assist other claimants at their refugee hearings. However, in 2013, he was killed under suspicious circumstances after being struck by a truck while riding his motorcycle in 2013. So there's another case of a deportee from the Sensi, B005, who was also arrested and detained by Sri Lankan authorities after being deported from Canada, and he subsequently has disappeared. So from the narrative accounts of the Tamil refugees, securitized legal proceedings have had a detrimental impact on their legal status, their sense of safety and security in Canada, their mental health, family relationship, their mobility, and ultimately for some, their actual lives. So I'll now hand it over to the remaining time to Sharry to wrap up our presentation with some concluding remarks and kind of tie all these themes together.
So let's look at the aftermath. We had two very important Supreme Court decisions, but at the same time, indeed, before the cases actually are decided by the Supreme Court, Canada behind the scenes is giving the Thai government millions of dollars to combat human smuggling and crack down on so-called illegal migration. The funds included money to train police as well as immigration and border patrol officers. So all of that is part of a comprehensive interdiction strategy that has been going on for decades, often somewhat under the radar, but it was very interesting that this sort of initiative got underway precisely in the aftermath of the arrival of the Ocean Lady and the Sensi. So the Sri Lankan Tamil refugees that were fortunate enough to access the assistance of the United Nations High Commissioner in Bangkok joined a very long queue as they wait for resettlement for years to a third country. So no longer possible to get on a boat. In fact, many individuals were subsequently rounded up by the Thai government, detained, and summarily deported. The lucky ones waited for years in a so-called queue. And I really emphasize queue in quotes because, of course, we all know there's no actual queue. So if we flash forward to today, relatively more recently, just in the last 2 years, this interdiction strategy has come to light, in particular, the migrant smuggling prevention strategy, as it's called. And the thing about it, which is important to underscore, is that the federal government is using this strategy to actively support interception activities in countries with documented human rights problems, right? So that's significant. And we know that this is taking place in a context where worldwide deaths are soaring on dangerous migration routes on both land and sea. And in a context when we've also got the highest number of refugees on record, right? So large populations of refugees and sort of burgeoning evidence of increasingly precarious journeys being adopted. And we also want to underscore, really coming back to this theme of racialization, Canada's very uneven response, right? So if we look at, for example, Canadian responses to the crisis in Ukraine, Immediate measures adopted to facilitate the arrival of Ukrainian refugees, not criticizing those measures on their own terms, but it deserves mention that we don't respond to crises in a similar way. And we can look at what's happened in Afghanistan most recently, the crisis this past summer, and yet what we see is foot dragging. And we see behind the scenes a securitized discourse about the very same people who helped Canadians during their time in Afghanistan now being securitized and not being facilitated to come to Canada. So we see, I think, some very stark contrasts at play. So we want to leave you with some questions, which will hopefully animate some of the discussion that follows. First of all, we ask, what are the cautionary lessons from this case study of securitized inadmissibility and Canadian colonial state building? Further, what are the benefits and risks or limitations of launching rights-based legal challenges and claims in courts? We saw the victories in Abuela Napa, and in particular, by the way, I mentioned by way of a postscript that ultimately those criminal prosecutions went back to the BC Supreme Court, and the cases were thrown out. So the prosecution was not upheld. But what are the benefits? What are the pros and cons? And more importantly, what other strategies need to be used to dismantle securitized immigration practices and support the wider project of refugee and migration justice more fundamentally? So that's just to get us started. If anybody would like to engage with either of these questions or bring us anything else, we're delighted to open the floor.
Thank you very much for that a wonderful presentation. It's a great example of the richness of socio-legal scholarship, that you've used methodologies that look to history, methodologies that look to legal doctrine, methodologies that include quantitative analysis, methodologies that include qualitative interviews, and you've woven them together into a very compelling, account that gets us to think about challenging questions. So thank you very much for that. I'm just going to stop the recording now so that everyone feels free to ask their questions without being observed. So let me just